This is our first video discussing legal remedies. We're starting our legal remedies discussion with compensatory damages. And this video is really going to focus on contracts, specifically what compensatory damages are available when you have a services or land contract or anything that's not a good. The case you were assigned to read was Dealer's Hobby, Inc. And so what happened in this case? Well, in June 1959, the parties entered a 15-year lease for a warehouse building. 14 years later, which was April 1973, the roof collapses. The contract, which is the lease, stated that the landlord was meant to maintain and repair the roof. In October 1973, the plaintiff decided to sue for damages to the property stored in the warehouse because the warehouse was mainly used for storage, as well as the difference between the fair market value of the premises as warranted versus in its current state, which is with the defective roof. And the plaintiff sued for the entire duration of the lease prior to the collapse, not just for that last year after the collapse. The issue addressed by the court as well as its holding, well, the first issue is, well, are the plaintiffs entitled to damages to the property stored in the building, which was about $17,000. The second issue is, are the plaintiffs entitled to the damages for the diminution of value of the property for the entire lease term? And so what was the holding? Well, for the first one, yes, the property that was in the building was damaged because the roof collapsed and the landlord was responsible for repairing the roof. So this about the $17,000, the plaintiff was entitled to that. However, the court held that the plaintiff is not entitled to the diminution of value of the property for the entire lease term because neither party had knowledge of these defects to the structure prior to the roof collapsing, which means the plaintiff suffered no harms for those 14 years. The plaintiff had no knowledge, which means the plaintiff had no harm. And so what were the rules the court used to make this decision? The rules were on page 553, paragraph 3. The court stated the principal underlying allowance of damages is that of compensation. The goal of contracts is to make someone whole again, to compensate, not to punish like criminal law. The ultimate purpose being to place the injured party in a favorable position as though no wrong had been committed. Again, that whole idea to make someone whole. However, the plaintiff's damages are always going to be limited to its actual loss. And these were the quotes of the court from the actual opinion, which seems very similar to the expectancy and reliance damages you probably learned in your first year contracts class. In your contracts class, you probably looked at the restatement, which defined these types of compensatory damages. Restatement 437 stated a party's expectation interest is measured by the loss in value to him of the other party's performance caused by its failure or deficiency, plus any other loss, including incidental or consequential loss caused by the breach, less any cost or other loss that he has been avoided by not having to perform. And then your reliance damages, which was restatement 349, as an alternative to expectation damages, right? So you can't get both. You get either reliance or expectancy. The injured party has a right to damages, including expenditures made in preparation for performance or in performance, less any loss the party in breach can prove with reasonable certainty the injured party would have suffered had the contract been performed. The gist of these, which again, you probably learned in contracts, was expectancy damages are putting the person back in the position as if the contract had been performed, giving them the benefit of their bargain. Whereas reliance damages are putting the person back to the status quo, as if the contract had never existed. The third compensatory damage you probably learned about in your contracts class was restitution. And so how does restitution fit in this case or in legal damages in general? Well, remember we talked about restitutionary damages earlier in the semester where you can get it under quasi-contract or replevin, which is torts. And now we're talking about compensatory damages, which are the expectancy, reliance, lost profits, consequential, incidental damages. But they're all types of legal remedies, substitutionary remedies that you get money instead of actual performance, right? So that's how it fits. It's the third type. It just kind of has its own category because there are also restitutionary remedies that are available as equitable remedies. So let's bring this back to our dealer's hobby case so you could see where the court's opinion, the actual quotes, relate to these restatements. where our first quote was talking about the goal is compensation. You're trying to put the person back in the position as if no wrong had been committed. Well, that's essentially in expectancy damages, prong A and B, which is saying we're giving him any loss as well as incidental and consequential loss. And in reliance, well, any expenditures made in preparation or for performance or an actual performance, we're giving you that money back, right? That's compensating someone, making them whole again for whatever losses they occurred. And then the second part of the opinion saying that the plaintiff's damages are limited to actual loss, that's the last prong, which is prong C in expectancy damages and B in reliance damages, where they account for any cost or other loss that has been avoided or whatever injury the party would have suffered if the contract had been performed. In those cases, they're saying, well, we're really just focusing on your actual loss. We don't want to give you a windfall. So the dealer's hobby case is a summarized version of the expectancy and reliance damages restatement rules. And the dealer's hobby case now took all these general rules and figured out, well, how do we determine the plaintiff's actual loss here? Because it's limited to actual loss. And on page 553, paragraph 9, the opinion said the usual measure of damages for breach of a lessor's agreement to make repairs or improvements is measured by the difference between the fair rental value of the premises, if they had been as warranted, and the fair rental value of the premises as they were during occupancy. But why did the court deny the plaintiff's request for the difference between the fair market value as warranted versus as they were during occupancy, when it specifically says in the rule statement that that was the damage or the loss the plaintiff actually suffered? On page 554, the court says specific rules, like the one we have here, are subordinate to the general rule. And the general rule is, well, no rule of law of damages permits an injured party to receive more than he has lost. And here, as we talked about in the beginning, there was no actual injury to the plaintiff because even though there could have been structural damages that made the fair rental value of the premises actually lower than what the plaintiff was paying, there was no injury because the plaintiff suffered no harm, right? There was no damage to property. The plaintiff didn't know. There was no issue. And so that's why the plaintiff only got the limited amount, which was about the $17,000 and not the like $200,000 that they were asking for the 14-year lease diminution in value. How do these compensatory rules apply to torts cases? Because torts could also be the underlying claim that you're dealing with. The general gist of compensatory damages is the goal of contract law and tort law is that of compensation, right? Remember, civil is to compensate, criminal is to punish. The ultimate purpose is to put the injured party in as good a position as he would have been if no wrong had been committed. So this is a summarized rule statement to memorize for the exam that encompasses expectancy, reliance, incidental, consequential, as well as a rule statement you can use if the underlying claim is torts. Now, in the bar, you'll probably have to use the expectancy and reliance rules that we talked about from the restatement. But for purposes of my exam, you can use this abbreviated statement that we have here. And you probably have to use a specific incidental and consequential rules for my exam as well as the bar. And so incidental damages are the cost to minimize other losses, direct or consequential, like admin fees or mailing fees, whatever you need to minimize things. Consequential damages are losses incurred due to the breach because of that injured party's particular circumstance. So it's something that flows from the breach that's particular to that person. Now, how does tort law define similar types of, compensatory damages? And torts law defines it as special damages, which are out-of-pocket losses, medical bills, lost wages, and general damages, which are pain and suffering, emotional distress, loss of consortium, and loss of joy, which we'll talk about in future classes. But no matter what kind of damages you're dealing with, tort law, contract law, you need to remember that the plaintiff's damages are always going to be limited to the actual loss to ensure the plaintiff does not get a windfall, right? And so this is, again, the rule statement that you can use on the exam. And we'll talk about other specific rules such as loss opportunity, loss profits, and loss of use. But here's the general rule for you to memorize.